On the 26th of June this year, the new Trust Registration Service provisions were introduced. They have their root in the anti-money laundering, terrorist financing and transfer of funds provisions. And as a result of these provisions, HMRC have introduced the Trust Registration Service to comply with their requirements under those anti-money laundering, transfer of funds, terrorist financing provisions. The Trust Registration Service effectively replaces Form 41G, and it really is, it applies to any express trust in the UK that has a UK tax liability. So we can exclude bare trusts and statutory trusts from that definition. Also applies to offshore trusts that have a UK tax liability. That's the important second condition for both trusts, is that there is a UK tax liability in the year. So if you have that liability in the year, then you have a requirement to register in the tax year. Who's the requirement fall on? It falls on the trustees, not, just for clarity, a financial planner who used a draft trust to implement a particular piece of planning for inheritance tax, for example, not an insurance company or a financial product provider or a platform that provided a draft trust. It's the trustees that have the prime responsibility. So it's important to just recognise, in summary, which trusts will and won't be caught by these provisions, which trusts will and won't have a requirement to register in relation to the financial services sector. So do trusts that hold an investment bond have a requirement to register? Well, not unless there is a liability to tax in that year, which will mean for most of the years that the bond is in force inside a trust, there won't be a requirement to register because there won't be a tax liability. If the bond is encashed, if the settlor is alive and resident in the UK, then the liability would fall on the settlor. So no requirement for the trustees to register because it's not their responsibility. Of course, after the settlor's death, or if the settlor is non-resident, then if the liability as a result of the encashment of the bond arose, it would be the responsibility of the trustees, the primary responsibility, and so there would be a requirement to register. There could also be inheritance tax driven requirements to register, for example, under the relevant property regime, 10-year charges, exit charges. So aside from those, should be okay with bond-based investments inside trust. The same for protection plans, perhaps even more so, because there's rarely going to be a chargeable event there. But if the protection plan paid out and the trustees held the funds for a while, maybe because the beneficiaries are young, then of course if those funds are invested and they produce income or gains, then there would be a requirement to register, which leads us to the next category. How about trusts holding collective investments, unit trusts, OICs? Then of course, if, and you hope there would be, some income is produced and some capital gains are made that give rise to a liability to tax, then of course there will be a requirement to register. How about unit trusts themselves? The word trust is in there, so do we need to consider those? Registered unit trusts do not need to notify under the Trust Registration Service, so don't need to register. Pension arrangements, again, relatively soft. These provisions could only apply to trust-based schemes, because if they're contract-based schemes, they're just not trusts, so there can be no requirement to register. Even for contract-based schemes, even for trust-based schemes, if they're wholly insured, again, no problem. And even if they're not wholly insured and they are trust-based, then it's really only SDRT and SDLT, stamp duty reserve tax, stamp duty land tax, that could be a concern. So relatively light on registration requirements for the financial services sector. The most obvious example are just bond-based trusts where there is a chargeable event or where there is an IHT charge, but that will be comparatively rare, not totally never going to happen, but comparatively rare. And of course, unit trusts, OICs, collectives that are held inside a trust that do produce a tax liability. There's a great bulletin, if I say so myself, I didn't write it, but there is a great bulletin on this in TechLink, so I'd encourage you to have a look at that to get familiar with these provisions.